Good evening, everybody, and welcome to another episode of Marvelous Medicine. This topic has generated a lot of interest. The Surrogacy Regulation Act 2021 having been passed very recently, we thought it will be a good topic for discussion. I must thank Dr. Gopinath for arranging this session and coordinating with Dr. Hitesh Bhatt. A quick introduction: Dr. P.M.Gopinath is the Director and Senior Consultant, Institute of Obstetrics and Gynecology and IVF at SRM Institute of Medical Sciences, Chennai. He did his MBBS, DGO and MD OBGYN from Madras University and was a gold medalist. He did his specialty training in fertility preservation at Sheba Medical Center, Israel, and is a ASRM board certified andrologist. He's the president of the Fertility Preservation Society of India and also a member of the International Fertility Preservation Society. He was a former professor of obstetrics and gynecology at Madras Medical College. Welcome, Dr. Gopinath. We look forward to a good session.
Thank you.
Answering the queries of which will be posed to him by Dr. Gopinath is Dr. Hitesh Bhatt. He's an advocate and partner in a legal firm called BNS Medical Legal Consultants. Dr. Bhatt did his MBBS, MD, obstetrics and gynecology from Baroda Medical College. After that, he did his postgraduate diploma in medical legal systems from Symbiosis as distant learning. Eventually, he did his LLB from MN Law College, Ahmedabad. Since 2013, he is practicing medical legal consultation exclusively. He is a medical legal consultant for 80 hospitals across India. He has authored 2 books, Consents in Obstetrics and Gynecology and Law Doctor Must Know. He has delivered more than 700 talks, including state and national conferences, and he is a life member of the Film Writers Association. Thank you, Dr. Hitesh, for agreeing to join us despite your extremely busy schedule. Thank you, Dr. Gopinath, once again for coordinating. Over to you, sir.
And thank you, Vidya. Thank you, Bhatt. Good evening
Thank
and
you, sir.
Welcome to this session. It is indeed a great academic platform, and it has got a mixed audience. In order to clarify to the non-gynecs and then other specialities, I'll just give a brief introduction and then we will start. When the man and woman try to conceive without any contraception, they average take about 5.1 months to conceive. So that means in any given month, the chances of conception is 20%. So by majority of them conceive within 1 year. So after 1 year, if they do not conceive, they seek medical advice. So when we see them, 1/3 are responsible, the male are responsible, 1/3 female are responsible, and the remaining 1/3, it's a both mixed factor. So what do? We investigate them, we guide them, we ask them to just take ovulation induction and plan the contact and make sure they conceive. If it fails, then we go to the next step, what we call it as an IUI, where we develop about 3 oocytes with a little bit of a milder stimulation, then plan for a timed trigger injection, and then do an artificial process where we collect the semen, wash, and then suspend them in the culture medium, and then inseminate it with a small fine cannula as an outpatient procedure without anesthesia. The next step goes for IVF, where you know that we aim for about 10 to 15 oocytes by a controlled ovarian hyperstimulation, take out the oocytes, and then fertilize it outside. And then the embryo is either transferred on the same cycle or on the subsequent cycle by a frozen embryo transfer. And everything goes well. This is roughly around 30% of them conceive. But here, there is a very small segment of the people who have got inherent developmental issues like congenital absence of the uterus, or some people who have undergone some surgical removal of the uterus. For example, a fibroid uterus where it is recurrent, where they are not able to just give them a complete clearance, they just do an hysterectomy. And in endometrial carcinoma, when we just do hysterectomy, when they plan for the conception, they take their own oocytes and then they take their own husband's sperm, fertilize it outside. This embryo is just given to a third party, what we call it as a surrogate. So this was a very common affair. So most of the people from abroad, they used to come and then just take this kind of a treatment here. There are a lot of hospitals which has about 300 beds, 400 beds only for surrogacy. So it is only for money the people come forward to just get pregnant and then deliver and then hand over the baby and go. So what we call it as a gestational surrogacy, by which the money transaction was taking place. So there are a lot of benefits, there are a lot of misconduct, and then there is a lot of issues which has taken place. So what has actually happened is, so in this, there was a long-standing formation of the law, which has been enacted from 25th of January. It has completely changed. You will hear from Bhatt what are all the implications of it in various aspects. So surrogacy is no more allowed for money. So he will explain to you in detail about it. So when the question to Dr. Bhatt, can you explain what are all the different types of surrogacy we normally come across?
Sir, there were like gestation, there were surrogacy, like commercial surrogacy and altruistic surrogacy. These were the two more common terms. And altruistic surrogacy is one which is happening out of natural love and affection. There is no transaction of any kind except love and affection. And the another kind was commercial surrogacy, and that is banned by the law at present. So we cannot go for commercial surrogacy. So now there are no types of surrogacy. There is only one surrogacy, that is altruistic surrogacy in India.
So why they put a ban on commercial surrogacy?
Sir, in law, there is no question you can ask as why. If they want to do it, they do it. So there may be some concerns, and it is a part of parliamentary debate. They must have seen that these surrogates are getting exploited or this or that, whatever reason they have seen. But whenever they pass the law, when it passes from both the houses of the parliament, signed by the president, we have to take it as it is. And there is no place for why in any law. Like 500 rupees currency notes were banned. Now we cannot ask why. If it is done, it is done. So you have to now follow the law as it is.
No, something would have kindled the lawmakers to take a decision to completely ban this surrogacy, right? So is it from the surrogates, or is it from the commissioning parents, or is it from the ART centers, or the watchful eyes of the law?
Sir, it can be anything. Some NGOs might have complained that the surrogates are being exploited and they are used for money and all this. So it might have raised their senses, and they have come up with this. But now I think instead of discussing why, we have to discuss what they have decided now further. That is more important, because whatever we discuss about that why, the law is in place now, unless and until it is nullified or it is amended.
And now, leaving besides the law, how do you see the surrogacy as a whole in the last 3 decades? You must have been following it up, right?
Yes, sir. And there were many instances of irregularities. There were guidelines in place, like 2010 ICMR guidelines were there, 2005 guidelines were there. Many forums like FOXY or ISAR or AFG, or so many societies of gynecologists, they had come out with various guidelines because when law is not in place, it is the guideline which should guide us. But as I always tell, that guidelines are like the instructions given to you by your mother. So if you follow or if you do not follow, there is no much difference. And law is the instructions given to you by your wife. You have to follow, otherwise you will have it. So they have come out with the law when you did not follow the guidelines. And there were guidelines, and we still used to see in the newspapers that a 70-year-old patient was made mother with the help of ART, or the children were abandoned by the couple after the surrogacy, or the surrogate was not paid enough, which was promised for, or the surrogate was taken up for successive pregnancies in spite of she having 5 cesareans. She was taken for surrogacy. So all these things might have created some kind of turmoil, and this must have been noticed by the NGOs and for benefit, because even if surrogate agrees to do something, but if it is medically not indicated or it is detrimental to her health, we should not allow her to go ahead just for sake of money. She might be in need of money, but we cannot allow them to exploit the way like bonded laborer law came, and even the child labor was banned in India. There was a need for money in the family. The children were working in this in the factories and all, but it is not actually medically indicated. The children of less than 15 years, 14 years should not work at the factory. So law has to come into place, whatever is the need of the families.
How do you think of the international, the state of affair for the surrogacy?
Sir, many countries do not even advocate surrogacy. That depends upon the need of the country. If the population is less, those countries will allow. If there are some spiritual, they have any, according to their beliefs, if surrogacy is allowed, then they will allow. Like in certain countries, surrogacy is not allowed at all. And here in India, we were even the foreigners where the surrogacy is either costly or banned. They used to come to India and were doing surrogacy here. So I think that also was the reason why before making the law in 2015, the government came out with the circular that no foreign surrogacy shall be allowed henceforth, and the visa or exit visa will not be given to them. And because that was a lot of concern when foreigner used to come to here in India, and they used to get benefit of the Indian absence of law and get surrogacy done here.
But we cannot export the gametes also, isn't it?
Now, yes. See, how I look at it is like the law is looking at the embryos as a potential child or a citizen. Suppose I want to become citizen of America, it is very easy for me to send the embryo outside to that country and implant it in somebody, and it will become a child in America and it will become citizen of America. So it is basically, it is a potential citizen. So I think government of India is also now looking into that aspect, and they will, I think, label each and every embryos. And they have even put ban today on the shifting of the embryos from one lab to another in India itself. Without their notice or without permission from them, you can't even shift the embryos. So they want to check the movement of embryos, where it is going, because these are potential citizens of India.
There is a case scenario where the patient has just done an ART and she has got embryos banked in one ART center A. She has tried a couple of times and failed. And since we do not allow them to just go in for a surrogacy now, she wants to take the embryos to go to some other center for surrogacy. How can the center A prevent or safeguard themselves?
Sir, previously, before these laws were enacted on ART and surrogacy, we were advising various consents, and we were allowing this because allowing in the sense we were guiding the centers how to go about it. But now only the national board will give permission, and then only you can shift the embryos. So you cannot, one center today cannot send another embryos to another center even within India after 25th of January 2022. So those things are out of question now.
So we can always say that it is under the law. We cannot just give you the thing until we get more clarity.
And there is a clarity. They have said that a national board will give permission. So we have to wait for the national board to be formed. and then only the embryos can be shifted from one center to another. There is no emergency in that. There is no medical emergency. And if at all you are in hurry, you can approach the High Court. High Court, if gives order, then you can shift the embryos. Otherwise, doctors themselves cannot shift the embryos from one place to another.
See, when you look at that law, so what are the changes in the law which affects the commissioning parents? So by commissioning parents, I mean the people who want to get the surrogate child. So now just for the clarity of the audience, that's what we mention it as a commissioning parent. What are all the laws which are enforced on the commissioning parents now as per the new guidelines?
First of all, it is law, not a guideline. There is a sanction behind it. The difference between law and a guideline is, in law, if you do not follow, there is a sanction, there is a punishment behind it. So you have to follow, you are bound to follow. Second thing, when the law is passed by the parliament and gazetted in a gazette, it is presumed that every citizen of India knows about it. You cannot say, I was not knowing it or I was ignorant about it, because a government cannot reach 130 billion Indian citizens and give them a copy of the law. Once it is gazetted, it is presumed that every citizen knows about it. So after 25th of January, it is done. Now, if you want to go ahead with the surrogacy, they have looked into various aspects of it. The indication, it was there in the guideline also that surrogacy has to be done for a valid indication. Just because lady is not having time, you cannot go for surrogacy, and that was the case in many cases. So that is not allowed now. There has to be a genuine indication. That indication will be decided by the medical board. The medical board will be formed under this law, and there will be a member like gynecologist, pediatrician. They all will be the member of that board. That board will decide whether this surrogacy is required or not. And if they authenticate this particular indication, they will give report to the appropriate authority. The authorities will be made, and appropriate authority in turn will give essentiality certificate to the commissioning couple. Essentiality certificate is the certificate which they will get after going through all the papers and all through the board. And medical board will approve the indication which your primary gynecologist has put, or any radiological evidence or sonographic evidence or any karyotyping or anything. They will approve it. It will be countersigned by the appropriate authority, and a certificate will be issued that will be called eligibility certificate for the couple. So that is the first thing the couple will have to get. The second thing they have said is order from the judicial magistrate first class. So the court of judicial magistrate first class will pass an order, and that order will be the order for that will serve as even the affidavit for the birth. The judicial magistrate first class will pass the order for surrogacy, and that order will serve as the birth proof. After the birth of the child, you have to give that to the municipality, and birth will be registered on the commissioning couple's name. So we were making an agreement between two parties with notary. Now there will be very less importance of that notarized document which we used to give to municipality to register the birth. Now municipality will not register the birth without the order from the court by the JMFC. So that is second thing the couple will have to get. And the third thing they will have to get is the insurance for the surrogate. The minimum expense which is allowed to be given to the surrogate is the insurance fees. That is one of the component which can be given to the or spent on the surrogate. That is, the one is all the medical expense. The second is any other expense as approved by the committee. And third is the expense for the insurance. So that insurance you have to take out for the surrogate, which includes all the complications which can occur within 30 months postpartum even. So it will cover 36 months in total, including postpartum complications arising out of this surrogacy arrangement. So that insurance also should be there. So couple should have three things at hand: the eligibility certificate, the order of the judicial magistrate, and this insurance copy. And after that, the appropriate authority will give eligibility certificate to couple and eligibility certificate to surrogate. So essentiality certificate, order from the JNFC, and insurance. These are the three things. And two more things are the eligibility certificate to the couple and eligibility certificate to the surrogate. Now, to get the eligibility certificate for the surrogate must have the following things. First, she should be married. Second, she should have a child of her own. Third thing, it should be only for the, it is allowed only for the one time in lifetime. She cannot become surrogate for multiple times. And she should be having the certificate of fitness for mental health and physical health from physician as well as the psychiatrist. If she is holding all this, and her age should be between 25 to 35 years of age. So if she is qualifying for all this, then an eligibility certificate will be given to her by the appropriate authority. Couple also will get eligibility certificate if the age of the female is between 23 to 35 years of age, and the age of 23 to 50 years of age, and the age of the man is 26 to 50 years of age. So the couple has to comply for the age, and also the couple have to enter into this only after the if they have any previous existing child, then also this eligibility will not be given to them. So if couple is having any previous child, either adopted or the child is born through surrogacy, or it's a naturally born child, it is only once for the couple also the surrogacy is allowed for the first child of theirs. If the previous child is having some disease, then there is some relaxation, but that also will be certified by the appropriate authority. Then only you can be given eligibility certificate. So couple will be holding two certificates from the appropriate authority, the essentiality and eligibility. Surrogate also will be holding one certificate from the appropriate authority, that is eligibility certificate. And then after all these certificates, collecting all this certificate, the couple and surrogate will approach the ART clinic, and ART clinic will do the embryo transfer.
And you were mentioning about the with the essentiality certificate, who will file to the magistrate for the magistrate order?
Essentiality certificate is from the medical board. It is from the medical board, but the magistrate's order that is required to be procured by the couple. It is couple who will do all these things.
Okay.
Couple will have to commissioning couple. Yes, commissioning couple will have to couple will have to approach the court.
So they have to file a petition.
Yes, they have to file a petition in the court to get this order.
So and then they have to get it.
Yes.
So what is the time frame for every step? Approximately you feel?
Sir, they have not given any time frame from this. It will take its reasonable time. That's it.
See, most of the people who come for surrogate, they are hard pressed, and then mainly because of the emotional stress and strain. They say, for example, somebody who lost their uterus in the first pregnancy with a rupture, and then now coming for a thing, they've created the embryos and just kept, and they have been waiting for the surrogate. What do we do there?
Sir, we have to wait. See, there are people, this emotional stress is not included in the right to life. It can be like they have said the mental health should be good, but just because, this is actually a need to have a child, that if I will get the child, I will be relieved of the stress. That kind of situation is there. So government at the most can offer the psychiatric treatment to them, but government cannot avoid all these steps. The steps which are mentioned in the law, that is there in the place. There are people who are in physical need of the organs, like there is Organ Transplant Act, and they also have to wait for years to get the organ, like kidney and liver. There is no emotional stress, or there is an emotional stress over and above, there is a physical stress. They are actually suffering from the disease. Still, there is a law in place and they have to go through all the steps. So I don't think that law, just because you say it is an emotional stress, government will avoid all these things. Once it is made, they may change.
Can it be made a little earlier? See, for example, if you go to the court, minimum it takes about 6 months for us to just get the magistrate certificate.
No, sir, it is not always so. That depends what kind of, in NTP, suppose, when the law was not in place beyond 20 weeks, we have got orders in 1 week from the court. If for this purpose also, like ART purpose, before this law was enacted, there was one husband who was on deathbed and the wife wanted to collect the semen. And we approached the Gujarat court and within 1 day they gave the order, because we said he's on deathbed, he may die tomorrow. And we want order to collect the semen because he has no will made. So the court said, we will allow you to collect the semen sample, but don't make embryos till further order. But at least collect the sample before he dies. So court is sensible enough if you represent properly. So that is a skill of a lawyer whom you hire.
Another thing you mentioned that the patient has to be a one-time surrogate. You know, see, usually when you take the oocyte donors, they are also mentioned it saying that they have to give it only one time.
Yes.
But how do we confirm it is only the one time she's got a surrogate? So she comes and tells me that she has got 2 children. She shows everything. She completely hides saying that she has undergone a surrogacy and just handed over a baby. There is no way we can confirm it from our side. Is it better? I mean, if we get an affidavit from her saying that this is the first time she's doing it, is it enough or something else has to be done?
Sir, we had made a affidavit for the same when law was not in place. Now, if law is in place, then for surrogacy, you are the most safe person as a clinician, because there are 3 more agencies before you, they will confirm all these things. There is appropriate authority, there is medical board, and there is judicial magistrate first class. If she can fool all 3, then don't get ashamed in getting fooled from her, because there are 3 more people who have already been fooled. So you are at a very safe zone, because she has fooled 3 more people before you, and it is a crime in the eyes of law. She has not followed something which is written in the law. And for altruistic purpose, I don't think somebody would like to take punishment also. So I don't think she will do that. And they are going to link the surrogates and the donors with Aadhaar card. Now, with the Aadhaar link, they are giving subsidies even. And every family is getting subsidy only once because of the Aadhaar link. So they are going to create Aadhaar link, and Aadhaar is already in place since many years. So that is the most reasonable arrangement which government is going to make, and it will come in no time. Aadhaar, just they have to give access to these government authorities. That's it. Once it is Aadhaar linked, there are 5 fingerprints on Aadhaar card. There is one Aadhaar card dedicatedly given to them. There is one mobile number on the Aadhaar card. So if all these things are linked, it is impossible for a person to do it again.
That is one. And second is how about the money transactions? See, after all, the surrogates are coming only for the sake of money.
Sir, now it is not possible. They have to do it altruistically. That's it.
If I can interrupt, who can try to get eligibility for being a surrogate? Who are the people allowed to be surrogates?
I told you, the surrogate's age should be 25 to 35 years of age. She should be married. She should have 1 child of her own, at least 1 child, and it should be for the altruistic purpose.
So this need not be a member of the family or anything. Unlike,
no, they have not mentioned that. Anybody who is ready to do altruistic work can become surrogate.
Vidya, you can just ask the audience to post the queries in the chat box, so at the end of it, we'll be able to take it.
So what
Yes,
is
I'll do
altruistic?
that.
I mean, I don't understand what exactly you mean altruistic.
Altruistic means,
in this context.
Altruistic means they have defined altruistic beautifully in the law, and they have said that whatever is not commercial is altruistic. And what is commercial? They have said commercial means commercialization of the surrogacy service, selling or buying of the human embryos, or trading in sell or purchase of the human embryo or gamete, or buying or trading services of the surrogate mother by way of giving payment, reward, benefit, fees, remuneration, or monetary incentive in cash or kind to the surrogate or her dependent or her representative. Now I think you have understood.
Yeah, so there's no money involved. In this.
Yes, that is what they say. Not to her, not to parents, not to anybody. Not in cash, not in kind. Not in India, not outside.
What is the law confining to the gay couples? There is a question from the audience.
ART is limited to Indian married couple, and Indian Marriage Act identifies only the heterosexual marriage.
Fine. So it should be for the Indian citizen married couple. They just have to get the essentiality certificate from the appropriate board. Then
Yes.
go to the next step.
Gopinath sir, if there's no money involved, why will anybody volunteer to rent
Sir,
their
I would like to reply this. If no money involved, why would somebody give liver and kidney? Then why can't uterus?
I think that's a good point. Yeah.
Can I say something?
Yes.
Can I say something?
Sure.
Yes.
Sir, I know Gopi, Hitesh, I'm a gynecologist.
Yes, ma'am.
So that I'm not sure. Okay, so the donors of liver or something will be somebody either who's dying or live donor, like
Yes.
kidney donor.
But
Correct.
there are live
So-
donors.
So I'm saying this lady has to rent a womb. She has to be exposed to preeclampsia, etc., etc. See,
Right.
अगर हम kidney donate कर रहे हैं, if we are donating kidney, then we have to be exposed to that, that surgery.
Yes.
So for kidney donation also, no money involved.
Yes, no money involved. You can, after 1994, no money. And still the transplant operation theaters are full. You have to wait for your turn to come. There are people who are doing altruistic services.
Since I interrupted, I only want to say that you are talking very well. That's all. I just wanted to say that.
See, madam, it is my job to convince the judge. I have to convince the audience.
Nee,
It's
you
my
did
professional
medicine.
skill.
You did both medicine and law, right?
Yes, madam.
I just want to say I'm very impressed, and I mean it truthfully and altruistically.
Thank
No
you.
money
Can I
involved.
ask Sanjay Nagral to come in here? Sanjay would like to.
The only person who can shut my mouth is my wife, madam. Otherwise, I can convince anyone.
I went and told my son about guideline and law just now because I'm living with my son. He follows my guideline and her law. I really enjoyed. Thank you
Yes,
very
ma'am.
much.
Thank you.
Sanjay, your comments?
He said he will get back in a while. So, there are questions again and again. So about similar things, but Dr. Hitesh has clearly said that at this point of time, according to the Act, only legally married couples as per Indian law are allowed to seek surrogacy. So, like he mentioned, the same-sex marriages are not yet officially recognized. So, whether it's 2 women or 2 men or whatever, as of now, they are not yet eligible for surrogacy. Am I right?
For surrogacy, they have included a woman. Woman can undergo surrogacy, like she can get services of the surrogacy only if she is divorced or widow between the age of 35 to 45. So if any woman, she is either widow or she is divorced, she can undergo or she can avail the surrogacy services. But here also there is a catch. She should be able to give her egg. So in Surrogacy Act, it is mentioned that the embryo should be related genetically to the couple or the women. So if she is not able to give egg, then she cannot take surrogacy. But if she is able to give her eggs, then she can undergo surrogacy. She can avail the services of the surrogate for altruistic purpose. Rest all things will remain same for her. She will have to get eligibility certificate, essentiality certificate, everything.
Sir, we have seen that Ukraine is...
Sir, 1 minute. Somebody has written that in section 2, surrogate mother has to be genetically related. It is for embryo, sir. Read the complete definition. The embryo has to be genetically related to the couple and not the surrogate.
And what about the embryo donation for surrogacy?
Embryo donation we can't do. I told you the embryo has to be genetically related to the couple.
One of them.
One of them. Genetically, to the couple means one of them. And
One
for
of
a
them.
woman, it has
So
to be
it could be
her
a
egg.
donor sperm or donor oocyte.
It was not allowed even before, sir. 2010 guideline also said so, but we did not listen because it was just a guideline. Now there is the punishment, so everybody will listen.
What about the punishment part of it? Is it to the commissioning couple or to the surrogate or to the center?
They have said whoever will not follow this. The word used are whoever will not follow any of the rules or the sections of the act will face this punishment. And in the ART Act, they have put 5 to 10 lakh rupees fine or imprisonment. Here there is no or, it is and. So there is a punishment in form of imprisonment and a fine. And the sections in the surrogacy are non-bailable, while in ART Act it is bailable sections. Here these are non-bailable. So you will have to get the bail from the magistrate. And for commercial surrogacy, the punishment is up to 10 years of imprisonment.
So, Dr. Hitesh, I should say that your body language, your voice, everything is like an advocate and not like a doctor. These are lawyers talk to us. By the way, the point I was coming to is the Ukraine being, it looks like a world capital of surrogacy. There are some Indian parents also gone to Ukraine and to have the surrogate children. What is that law? Anything to do with you having surrogate elsewhere?
Sir, in India or in any country, there is a dictum that the thing which you cannot do legally or by legal means, you cannot do it by illegal means or by any other way. So if surrogacy is done there, they bring back the child, it will be very difficult from them to get the child or to get the Indian citizenship. There are instances where in Germany, surrogacy was not identified and people got surrogacy here and tried to take the child back to Germany and the Germany refused to give German citizenship. So if something is not allowed in India, you cannot do it outside. You are still committing a crime. There is a jurisdiction section in the our constitution and IPC that you cannot do it. Any crime committed outside India will be considered as crime committed inside India by the Indian citizen. Even sex determination, there are people who are going outside and doing sex determination and come back to India. It is just because they don't get caught. If they get caught, if there is enough evidence or a complaint against them, a case can definitely be filed against them in India.
So there is a question.
Hitesh, there is a question. Supposing if there is you are going for a surrogacy because of the recurrent pregnancy loss, and you go through all the guidelines and go into the surrogacy, what happens if the commissioning parents become pregnant during that time?
Nothing, sir. That is fine. If they become they will have 2 children. That's it.
So they cannot break the...
No, they can, if suppose they want surrogate to terminate the pregnancy, then also the permission of appropriate authority is required. So they can get termination of pregnancy in surrogate. That is also possible. They want to keep 2 children, they can do that. It is just like if somebody conceives naturally with twins, she can either go for fetal reduction and have 1 child, or she can accept 2. That is up to them what to do.
But who has got the power? See, for example, you are talking about twins. So if you want to reduce it to singleton, either the surrogate or the commissioning couple.
It is commissioning couple. Surrogate, once transfer is done, surrogate cannot withdraw consent. Even for surrogate to terminate the pregnancy, she will have to go to appropriate authority. She cannot terminate the pregnancy without medical indication.
So even the fetal reduction for a twins, it is only the commissioning parents who decide.
Right. Because the fetus cannot give consent from womb.
How long do you think that it will set right? Now we are in the waiting period, right? We
Right.
cannot do anything. We have just stopped everything and we are waiting.
Right. So they said the boards and everything will be formed within 90 days of the enactment. So the boards and everything will be formed within 90 days. So we have to wait for 3 months. Up to April, we can say.
Dr. Sanjay Nagaram, we'd like you to unmute yourself and speak, sir.
Yeah, can you hear me?
Yes,
Yes, sir.
Okay. So thank you.
We can't see
Very,
you
very
though,
interesting.
Simon.
Actually, I'm in a rather odd situation, so I don't want you to see me.
Okay.
So, okay. Anyway, no, I am in my car, so I mean it's okay. So I just had two comments which I've posted on the group, on the chat rather. The first is about the analogy with organ donation, which has its limitations because organ donors are usually, at least as per current law, close relatives, first degree relatives, sometimes second. The second thing is, of course, in organ donation, you are saving life. In surrogacy, you're not exactly saving anybody's life. There is an option of not having a kid, or there is an option of adoption. I think the other key issue is that is the surrogate told that potentially she can very rare, but die of a pregnancy. So is it a genuine informed consent?
Yes. Yes, sir. See, surrogate will have to give a consent. There will be consents taken from the surrogate. At present also we are taking. And she must have one child. So she is already aware about all the risks which are there in the pregnancy. Still, it is duty of the doctor to tell her all the risk involved in the process. Not only for surrogacy, it is there for ART as well.
Yeah, which often is, which I suspect often is not explained, and that was the problem with the old. Before this law, there were surrogates who had complications.
Yes, but see, there are consent forms also, and that these are detailed consent forms. Even we created detailed consent forms for various process. We have put it up on net also. So those consents will be signed by the couple, and it is duty given to the ART clinic and surrogacy clinic to counsel before any process done onto them. And usually the doctors do that, or there are counselors kept. Even there will be post of counselor in the ART and surrogacy clinic. Then only they will be given license. So there are official counselors, and they will counsel the couple for the risk involved, the benefits, and the process and everything.
Right. Thank you.
So Gopinath sir, there are too many questions in the chat box.
Vidya, can you just take up the questions, please? Please unmute, Vidya.
If a young couple who has, I don't know what AMH means, azoospermia, can they go for I mean, we're moving a little bit away, but they want to take your advice because of your legal status. If a young couple who have azoospermia, can they go for donor embryo?
I'm not getting it. Azoospermia, why should they go for donor embryo? There has to be female indication as well. See, every procedure you do, there has to be indication. That's it.
I think it's low AMH. They forgot to write the word low.
So fine, then it is a medical indication. You should be able to prove it, and the rules are going to come. They will give a list of indications for which you can do, or you have medical books. You read medical books, confirm the diagnosis, and then only go for the any plan for the treatment.
No, Hitesh, I don't think they will be eligible because it's an azoospermia and a low AMH. So it's going to be both donors.
Exactly. So in embryo donation, they only said, I think the question asked was embryo donation. So it has to be indicated. See, law books will not teach you medicine. You understand one thing. In law book, hardly anything is written about law. How can it teach you medicine and indications for embryo donation and indication for the third party reproduction?
See, the problem here is for surrogate.
Will it be legally allowed? He's asking. I think the question is donor embryo, will it be allowed?
So in law, the lines are written as do it for indication. That's it. You should be in a position to prove that there was an indication. And that is true for every procedure we do. If you do hysterectomy, you should have valid indication. If you do cesarean, you should have valid indication. And that should be authenticated by the books. If when the court case comes to the court, we have to show our medical books to prove that we are not negligent in doing this procedure.
Dr. Deshmukh, you can unmute and speak. Your hand is up. Dr. Deshmukh?
But it is very clearly mentioned saying that you cannot take an embryo donation for surrogacy.
Hello.
Yes, it is not for surrogacy.
Yeah.
Please continue, Dr. Deshmukh.
Can you hear me?
Yes.
I would like to ask, as sir has told that in 2010 we have passed law of not using donor embryo. So in that case, if the patient is having AMH 0, you can't retrieve any oocytes, and husband is also spermic, in spite of doing TISA, you can't retrieve any sperms. So in that case, can we go for a donor embryo? That is a real indication.
Donor embryo in surrogacy, no. Law doesn't
not
allow.
in surrogacy, sir. Not in surrogacy. Surrogacy, though, we know that we have
So
to use.
self, you can, that is what, if there is indication, you are convinced, and there is books which says that you can go ahead and do that treatment to the couple.
No, sir, but as you said that 2010, the law has been passed that donor embryo is not, you can't be used.
For surrogacy, donor embryo for surrogacy.
Yeah. And what about the essentiality certificate? How should we go ahead with that essentiality?
It is for indication. Authenticating appropriate authority will give after taking advice of medical board.
So now we should practice donor embryo or not for indicated patients or not?
But not for surrogacy, madam. All things are for surrogacy. There is no essentiality required for ART in couple. It is for surrogate only.
Achha. And one more thing, and are we supposed to take this is out of the way? Are we supposed to take oocyte donor only from the oocyte ART banks, or we are supposed to recruit our own oocyte donors till April?
There is nothing like till April, till the boards are formed or till the authorities are in place. You can act as a bank, but you have to follow everything which is written in the law for the bank.
Yeah. And can we recruit our own oocyte donors with all the guidelines
Can
mentioned in the
you should. It is not can, you should.
Yes,
you cannot use agents.
Okay. Yes, that is good. Thank you, sir.
Yeah.
So there's another question: is surrogate's husband's consent needed?
That will come in the rules, but yes, it was there in 2010 guideline also for any process of related to progeny or related to producing a child or giving child for donation or taking adoption or taking child for adoption. So similarly, if you are giving your genetic material to another couple or accepting genetic material of another couple, the consent of both husband and wife is required, because the child belongs to both of them and it's a joint account. So signature of both is required. At present, it is not there in the main act. It will come in the rule.
Right. There's a very long question which I didn't really understand, but I'll just read it out. What happens after getting all these essential certificates, but the couples have already recurrent pregnancy loss of without particular cause? This surrogacy pregnancy also becomes negative or aborted or stillborn. What will be the benefit for commissioning couple and surrogate mother? I didn't understand the question, but I suppose no benefit.
But if there is the point is, if there is indication, surrogacy will be allowed. That's it.
No. In case if in the surrogate, if he happens to abort, what does they do? That's what is the question. So, but it is, you have to take it for granted.
It will come in the rule. It will come in the rule that in the same surrogate you can transfer for 3 times the embryos. That is what was there in previous guidelines also. So you can transfer the embryos 3 times into the same surrogate within 1 year of time. So if she aborts, you can again put the embryos into the same surrogate. Or if you change the surrogate, you have to do whole process again.
How many embryos can be transferred to surrogate? Is there any change?
They have mentioned that it will come in the rules.
But as of now, it is only 2.
They have not mentioned that in the rules. At present, they have said that in the 2010 guidelines, it was not that they have said 3 embryos, not more than 3 for anything. But here in surrogacy, they have said that number of embryos will be decided in the rules. So we are waiting for the rules to come.
So Dr. Kaushik Das, the answer to your question is that the surrogate mother need not be a relative of the commissioning couple. Dr. Hitesh has already answered that question. And Dr. Deshmukh, I think you have got the answer for eligibility certificate also, right?
The key question is whether the surrogate is informed that she can potentially die of the pregnancy. See, usually the Supreme Court has said in the case of Samira Kohli versus Prabha Manchanda that you have to tell the reasonable complications to the patient. No doubt, death is always a complication of any procedure. But we usually, if there is that much danger to her life, we don't go ahead and select her as a surrogate, that first place, because she will require medical certificate as well as the certificate from the psychiatrist. So death need not be told in such a way that she will not go for it. Otherwise, there is a risk of death even in property insertion. If you say that, then nobody will take the property. So you have to be reasonable in telling the risk. And if you see spiritually, death ultimately is the ultimate occurrence of life itself. Right? Every life is a lethal disease. It ends into a death eventually. So we need not tell all these things. If she is that much having that much potential, she has to die, then we cannot take her as surrogate.
Nilesh Sarojkar, the answer is no. At this point, anybody, you will not get, if you have a normal reproductive system, you will probably not get an eligibility certificate. So you cannot get surrogacy. That is as per the new law. Am I right, Dr. Hitesh?
What? For what?
And there's a question about if somebody has a normal reproductive system but wants to do surrogacy, that won't happen now, isn't it, sir, right now?
Unless the board approves. See, it is the board who is going to decide. If board says yes, do it, then you are nobody to say no. Go ahead and do it.
Vidya, there's a question about single women, can they have surrogacy like some celebrities?
I told no, she should either be widow or she should be divorcee between 35 to 45 years of age and able to give her eggs. So if she is separated, she will not get that benefit. She has to be either divorced or she has to be widow. So either she will have to divorce her husband or kill him to get this surrogacy benefit.
That is legal language.
And there's a question, can if the surrogate refuses to continue the pregnancy at 18 weeks for personal reason, is it allowed?
No, she cannot. She has entered into the act. She can do it, but then she will face the punishment, or she will face the because without any medical indication, she cannot. But cannot mean this. What I mean to say is, she can do it, but then she will have to face the whatever the sanctions are there. For that, she will have to take that. Nobody can force her to remain pregnant. That is at first place. But she is actually infringing the contract. So she is actually infringing the guidelines given or the law, the sections given in the law. So you can go to court, you can take the recourse, and court will decide what to do with her.
There is a little bit of a morbid question. Sir, what happens if the commissioning couple dies before delivery of the surrogate child? Who will be in charge of the child thereafter?
That is what is always written in our contract. There will be a contract that in death of the commissioning couple or the couple refuses to take the child, what will happen? So there are nominees mentioned. It was there in 2010 guidelines. There are names of 2 nominees, and they will take the child, and they were within their rights to give the child to orphanage afterwards. But they have to take the possession of the child at first, and they have to manage the child and then give it to the either for adoption or to the orphanage.
Ghosh, you have been silently listening. Are you aware of what are the laws in US and how they compare to the new laws in India?
No, this is all great news. I was just applauding Dr. Hitesh Bhatt's brilliance and eloquence, as well as the brilliance of Dr. Gopinath to kind of stimulate him to get out all these questions, and our panel. This is outstanding. I think even the knowledge of guideline and law is so important. We are in a social contract with human beings to do the best things, and all these laws come into place because a fraction of human beings do not follow the normalcy, and they take devious methods, either money or whatever, and it messes it up for everybody else, and that takes some regulation. I don't know whether these current methods are very organized, systematic, well thought for. All the possibilities have been thought for, and how is it deterring people to go forward And if anything, which some of these laws have done, they both protected us and has inhibited science. And that's always a debate for us as to, in US, we can't go with the embryo, and anything to do with a live donor is vigorously debated. From a scientist standpoint, it's like it's inhibition of science, but from a social standpoint, from a entire what Dr. Bhatt said, I don't know whether I need to call you Dr. Bhatt or Lawyer Bhatt or combination of both, is very true, because you are bringing in a life which the society also has a responsibility of it, and the child has to deal with the consequences of what is set forth, because he or she is going to lose their parents and they will be left alone to deal with a lot of these rules. So I think these are in the right frame, even though it seems punitive. It seems to be very well thought of. But there is a small group of, there is not going to be small, there is going to be a sizable group of parents who will just be exhausted with the length and regulations of what has been put forward. I, for one, am so grateful that I didn't have to put my parents through a surrogacy to bring me forth to life. That seemed to be sending them to a psychiatric hospital if they had to do all that stuff with the money involved. But having said that, I'm very thankful. Dr. Bhatt, we have an MD-JD program in US, and I do have a couple of colleagues here who are MD-JD. They don't have your brilliance, I can tell you that. They're more MD than JD. I wanted to know, side aside, is this an established program in India, or you were just hit by a lightning that you wanted to do this? Because it seems to be, as Dr. Radhakrishnan and others, they do complicated procedures. There seems to be a need for somebody of your capability and brilliance to guide and talk to us in a law, with a law language, and medicine with the medicine, and talk the common language, which we are a privilege here in US, but I wanted to hear from you. It's a side question, but it's kind of very needed.
Thank you for your kind words, sir. It humbled me, and I'm thankful to you, sir, for the same.
How many lawyers are like, how many MD, CPS, MD, LLB are there in India? Do you have any idea?
Sir, there are a couple of them. See, doing LLB is not very difficult task, but leaving medical practice is something which I took a step forward. And there are I know of some 5-10 people, but they have done it after their retirement. I did it at peak of my career. It was not that I was bad gynecologist. I'm gold medalist too. I did it just because nobody was doing it. I wanted to do something because the doctors were unaware, they were frightened, because it is the ignorance which gives you fear. If you know it completely, or you have to be totally ignorant. If you know half, then you are always at fear. It is like a small child. A small child will catch the snake because he doesn't have a knowledge. Or a snake catcher will catch the snake because he has full knowledge. The people like us fear the snake because we don't have full knowledge or half ignorance. So that was the main aim. I wanted to make them enlightened with the law. And that is how I entered into this.
Sir,
thank you.
As an advocate, you'll be very good at finding out loopholes in the law, because you will use the loopholes to in favor of whichever party you are representing. You'll represent both the sides as a matter.
I represent only doctors. First thing, I don't take patients' cases. But the thing is, in law, I always tell, in medicine, difference between law and medicine is, in medicine, you have to do exactly what is written in your books. Suppose a patient comes with malaria, I have to ask the history as mentioned in the books. I have to do test as mentioned in the books. I have to give medicines as mentioned in the books. But if in law, if somebody comes to you with say, I have committed a murder, you save me, I cannot say you hang yourself because it is written in legal books. I have to find out the ways to take him out if at all I want to. But, and that is why there was some moral, this thing, if I should not be saving anyone who is doing wrong. So we are into preventive medical legal now. So I am guiding doctors to do ethical practice. I am guiding doctors to follow the law. I am guiding hospitals on how to keep records, how to keep documents, how to communicate, what consents to be taken, what all to be told, so that they are on the right side of the law. And then I defend them.
Hitesh, one last question.
Yes, sir.
When the surrogate is gives birth to a child, it is registered on the commissioning parent's name, right?
Yes.
What is the legality of the child? I mean, do the commissioning parents have to inform the child later? Do they have any written law about it?
Yes, they have said that the child has a right to know it, that they have born through surrogate. That was there in the previous 2010 guidelines, and it will come in the rules. It will come in the rules that child becomes more than 18 years of age. It is his right to know. And you can tell that the child has born through either the assisted reproductive technique or through surrogacy. However, at that time, they were anonymous. The donors were anonymous. So child will not come to know about the name of the donor unless it is required for the child's health. Then the couple can go back to or the child himself can go back to the hospital where their parents took the treatment and get the name of the donor for which some test or genetic disease if that person was suffering from, to get some records. Otherwise, he is entitled to know that he is born through a donor eggs or donor embryo or through surrogacy after the age of 18 years.
So there's a question saying, what do you think are the likely loopholes that could come up in this law?
We have to wait for the rules to come, and the loopholes we will see, because there are no loopholes at present. There are conflicts, right? Say in the sense, I would like to say, at one place it is mentioned in ART Act that the bank is somebody who supplies the eggs, but in one place it is section 27. It is mentioned that the provision of the donor will be done by the bank. So this type of conflicts are there that will be resolved by the rules. And if rules also have some problem, then we can say that these are the loopholes in the law.
This question has been repeated again. For PGT, should we have separate PCPNDT registration apart from our routine?
Yes.
It is invasive prenatal diagnostic procedure. So you have to get it mentioned in your registration. In registration form B of PCPNDT, there is mention about the procedure name, amniocentesis, CVS, this, that. The last is any other. In any other PGT or PGD, it is not actually PGT, PGD. You have to write embryo biopsy, because what we do is embryo biopsy. We don't do PGD, PGTs. It is done by the genetic laboratory. We do embryo biopsy. So we have to get embryo biopsy written over there as a procedure.
Is it okay to mention that the child was born of surrogacy in the discharge summary?
100%. Even you have to mention about the embryo, the constitution of the embryo, whether it is donor sperm or donor oocyte.
But most of the time the birth is happening at a place other than where the
you have to give discharge card to the after the surrogacy is done, the summary to the couple of what procedure done on that couple, for that couple, right? So that summary will include that.
So we will, Dr. Padmapriya, we will try and get Dr. Hitesh Bhatt again to talk about general part of medical legal things, so that maybe you can all keep your questions for another session. Today we'll kind of focus more on surrogacy or anything somewhat related to it. Dr. Hitesh, you will be kind enough to join us in the coming weeks or months for another session on medical legal advice, like what you're saying, preventive medical legal coaching and hand-holding that you're doing for doctors.
I have been working with Hitesh for the past 8 years. So he comes every month, audits the entire case sheets, and he just tells us where we have gone wrong, what should be done, and how we have to correct it. Within 2 days, we do the correction and send it back to him. So our replies. So that way, you know, all our case sheets have been audited, all our procedures have been audited. So for the past 7 years. And I was working with him in Nova in 2014. And after I have come to SIMS, he has been with me.
Sir, we are thankful to you, sir, for that. It was something new which we did. It was my brainchild to do that, and you supported us wholeheartedly. You accepted us. That time, even there was no much concern about all this, but still you accepted that thing. You advocated that because you are ethical and you wanted to do ethical practice, you allowed us to do that, auditing for you. And now we are catering more than 120 centers, and we are saying no to other centers who are coming to us because we don't have capacity to cater. I don't have juniors to work for me. But I'm obliged that you recognize our things and you supported us at that time, sir. Thank you.
Last question, sir. What will be the insurance amount for surrogate mother till 36 months?
Anything. You have to, that will be decided by the insurance company. But usually whatever complication happens, you are responsible because she is doing it. Suppose your own wife is under treatment. What you will spend on her? The exact same amount you have to spend on the commissioning, as a commissioning couple onto the surrogate. But since you cannot assure that, at least you have to take insurance, and government will decide what will be the maximum expense that can occur behind a surrogate for some complications.
Your closing comments, Dr. Gopinath, because
I want to have one comment before sir comes in. How lucrative is your profession, sir? Because when it comes to doctors, people cringe and they're very hesitant. But when it comes to lawyers, they pay bundles and bundles of money without hesitation, and nobody has any problem. So, how lucrative is a lawyer's profession? And
sir, I have never given importance to the money because I was hand to mouth when I changed the profession for a few years because we had only few clients. So it is not a money that concerns me. And if I want to earn more, I will be taking patients' cases and filing cases against the doctor rather than supporting them and helping them in making the things right. So money is never a concern for me. My concern is to reduce the conflict between doctor and a patient.
Right.
Money is a byproduct, sir. I can say that. Money is a byproduct of my aim.
Dr. Gopinath, your closing comments, sir. This whole session was planned and executed by you, thanks to Dr. Hitesh. So your closing comments.
Thank you. Thank you very much, Vidya, and thank you, Dr. Patta. So it was really an honor to share all our views with you. And it was indeed a great pleasure in our foreign faculty, foreign delegate, acknowledging the presentation of Hitesh Bhatt, and it was really nice. So we have thought about surrogacy as an entity of ART, which we have been regularly doing it. But however, we have been doing ethically because he has been auditing our surrogacies right from contracts. He has been doing it. So we have been doing surrogacy at least about 2 to 3 per year. We have been doing it. Now with the law, we are to a certain extent, we are really sort of, upset about it. For example, we cannot apply it in a fertility preservation where it is most important. Now we have to wait for the law on time frame and then authorities. Probably as it is just like he mentioned about that 500 rupees note, when it came overnight, we were not able to accept it. But over a period of time, we have come to know that it is not existent and we have just come back. The same way, if the law, we have to go by the law and they will come with more clarity. And as he has rightly put it up, it helps our ART people. And there are about 3 front lines. So the essentiality, judicial magistrate certificate, and then with all that they come to us and we go through it. And then if we are absolutely safe as long as a surrogacy, when you do it altruistic and no money is involved. But it is very, very difficult to get the surrogate who will come and do unless they happen to be a close relative of them, just like a organ donation. And I thank everyone for the patient listening. Probably when the law comes, when it is in black and white with all the appropriate authorities, we will come back with more information in subsequent sessions. Thank you very much.
Thank you, sir.
Thank you, Dr. Hitesh Bhatt. Thank you, Dr. Gopinath, and thank you everyone for joining and making the session so lively with all your questions. We'll meet again next Thursday with another episode of Marvelous Medicine. Till then, take care and stay safe. Good night.